watakaofikishwa mbele yetu kwa njia ya haki na uaminifu ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao wamezikabidhi mikononi mwetu. First order.
Statement from the chair.
Honorable Senators, this morning, at the commencement of the hearing for the removal from office by impeachment of His Excellency Gachagua, the Deputy President of the Republic of Kenya, Legal Counsel for the Deputy President, Mr. Ndegonjiru, Learned Counsel, raised a preliminary objection on the legal representation for the National Assembly. Learned Counsel opposed. Learned Counsel submitted the 160 of the Constitution, as read together with a time state officer, to the Deputy President if the session of the decision was taken in Kisii County from appearing in the Constitution and Section Public Prosecutions versus Orengo, Manduka and two others interested parties, Constitutional Petition 204 of 2019, where Honorable Justice Ogola by the respondent, Honorable James Orengo, spirit of Chapter 6 of the Constitution, failing to conform to the mandatory provision of the Leadership and Integrity Act. The judge ruled that in that case, there was the petitioner highlighted by the fact that the interested party, Mr. Manduku, the managing director of KPA, may at one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petitioner was being investigated on. In this, that restricts activities of state officers, and it specifically prohibits a state officer from engaging in any other gainful employment. Gainful employment and employment. Council interpreted articles. Council also cited the decision of the court in the Mwinu case, which defined conflict as where one is confronted by two different interests, where one is competing with the other. Learned Counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise for the National Assembly so to distinguish Mrs. Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator. The fact alone is a violation of Article the applicable test. The only applicable proved that Senator Orengo was providing pro bono service. Constitution provides of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration, impairment of the judgment of the state officer in the execution of the function of the state office or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is tried law that he who asserts must prove. In this regard, I wish to observe that the Learned Counsel for the Deputy President did not adduce evidence to prove the need and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that Counsel attempted to shift to the ruling of the Senate that barred Honorable Osoro from appearing for the County Assembly of Kisii. In the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Osoro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, confidence in the impeachment process entirely is true. That in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the Counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasions are moot. Honorable Senators, ladies and gentlemen, for the National Assembly, the Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within their time during the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate. A true reading of this rule, every material for it is what is contemplated to have been sent to the Speaker of the Senate. The question, therefore, that with the National Assembly, our answer to that, Mr. Speaker, sir, is an emphatic no. And why do we say no? We say no for the first reason that the reference to the letter forwarding the material that came from the National Assembly to that report, deliberations in relation to that follows, therefore, of the material. In addition to the material that was presented by the mover of the motion to the National Assembly, the honourable members of the National Assembly had their deliberations, which also captured in the Hansard. In that Hansard, as part of the evidence of the proceedings before the National Assembly, the Hansard from the National Assembly forms part of the report that was presented before you. The report on the public participation too is an important component of submission, Mr. Speaker, sir, to allow that material to be before this Honourable House is the all-celebrated test of relevance. Mr. Speaker, it's a judicial proceeding. It is, what is important is that the material that is at the House determine the truth or otherwise of the issues that have been raised for the consideration of this House. How then, Mr. Speaker, sir, do we get that my learned friend, Mr. by one Mr. Peterson Njomo Mushira? Mr. Speaker, sir, Mr. Njomo Mushira says that he followed the proceedings of the Republic of Kenya at part 1.1 of his response. And he says that he has personal knowledge of the items that were contained or that would give clarity to part of the assertions in response by His Excellency in Volume 6, the Deputy President. At part 1. In particular, at part 1.1.4, His Excellency the Deputy President says, in accordance with his instruction, Njomo Mushira, which indicates that number one is a shareholder to the company which bought that hotel, and that according to him, Mr. Speaker, sir, he got into a secret tradition that that is material. Speaker, sir, I urge that that objection we need.
Mr. Speaker, sir, with your kind permission,
Very well, you may go ahead as I put my thought.
What my learned friend has raised. The application or the objection had nothing to do with that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was hearing David, one Jomo, was brought. The question rights be, this is not a witness of this information assembly. Where does it sit? Is it a state organ? Hold our ruling and justice be seen to be done, even the people following these proceedings. I am most obliged.
Honourable Senators, the second preliminary objection raised by the Council for the Deputy President, documents of the National Assembly, an affidavit sworn by Mr. Peterson Njomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to action of these two documents. Counsel for the National Assembly opposed the provision 20 of Part 1 of the second schedule to the Senate to introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker, the bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7, to appear to both parties relied on this matter. I will repeat that. The parties were required to do documentation, having analyzed, objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed to be referred to this. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be introduced, or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that rules of procedure. I therefore rule that the objection is hereby dismissed. Now, honourable senators,
indulgence, we as well to Mr. Speaker, sir, there are quick housekeeping issues. If you permit me just in 2 minutes, I may be able to the bundle of documents that we have filed before this House to have documents. Mr. Speaker, sir, when we were perusing in that volume 4, running from page 135 to 140, others in the course of this availed that document. It is not a new document. The only thing that had happened is that we forgot, or rather inadvertently, we didn't get the even numbers printed. We have since done that, Mr. Speaker, sir, and with the permission, we urge that we be allowed to rely on that document. We filed it, Mr. Speaker, sir, and served it to our colleagues relied upon. To yourself, to have someone speak testimonies to us before you. We, in our letter, did indicate the specific item that is to testify to, and it is equally our humble plea that I'm most obliged, Mr. Speaker, sir.
To be some pages were left. We are going to examine that and see what was served on us and what those pages that are now being introduced contain. With regard to summons to ask individuals from the Anti-Corruption Commission to come, we draw quasi from office of the Deputy of the People of Kenya. Statement on it is to enable the other side, in this case the Deputy President, to seek legal advice, to give his 2 days for this trial. And one of the issues we'll be raising is these allegations, and you are going to go, who are trained to investigate any object. This is out with their witness statement and affidavit. The case of the Deputy President will be irredeemably prejudiced. So we object very strongly to that application.
Counsel for National Assembly.
To the objection that was extended but to a list of witnesses. And Mr. Speaker, sir, all we seek is a confirmation that our response has been actioned. What this August
Stated that you have no problem with the first.
I want to see those pages.
Has not gotten that document, you must also that document. Senator Mazayo, Mr. Lasiga, Senator Kajwang.
Just letter dated the 14th of October Assembly indicate that the Ethics and Anti-Corruption Commission will be asked to produce any other witness, affidavits, or documents. Thank you very much.
Speaker, sir, if I may.
Just take a seat. Senior Counsel Paul Mitchell, are you in receipt of the document now?
Mheshimiwa Speaker, this document, we are seeing it for the first time now. Many pages, so we were quickly of this honorable House. Perhaps you can give us an opportunity to go through these documents, because we need to go through them. Inaonekana kama hii ni ukarabati, but let's go through it. Perhaps if witness giving evidence and so
President, Senior Counsel. Now, the other name that has been raised is on the issue of summons to witnesses. Now, if you look at our rules of procedure, more particularly rule number 10, which provides the President, invite or summon any person to appear and give evidence before the Senate. So the summons that have been sought of our rules of procedure, if there evidence, legal team from the Deputy President, you may raise an issue, and I'll certainly hear you at that juncture.
Permit me, Mheshimiwa Speaker, to place it on record that the rules of this material has to be respected. Article 25C, that cannot be compromised in any manner. There has been no explanation why the EACC was never asked to investigate the allegations taken, because the National Assembly cannot investigate criminal offences. In fact, in implementing Chapter 6 of the Constitution, you want to reverse the reported or the matter being investigated or him being convicted. Mheshimiwa Speaker, I plead that you reconsider court in order for the Deputy
Senior Counsel Paul Mitchell case. What I said, there was some invitation that was sent to both parties, and each party was requested to submit a list of witnesses. The National Assembly submitted a list of witnesses with a request under Rule 10 of the National Assembly, and it is permissible and it is within our rules of procedure.
Mheshimiwa Speaker, you are
Senior Counsel ruling of the Speaker is final. So let's leave the matter there. I've made my ruling. Let's make progress, Senior Counsel.
Mheshimiwa Speaker, I agree entirely. I've seen.
Move this hearing. Honorable Clerk, you may now proceed to close the next order. Summons to issue to those who...
Hearing and determination on the Deputy President of the Republic of...
Honorable Senators, ladies and gentlemen, we are going to move to the opening statements, starting with Counsel for the National Assembly. Your time starts running from now.
A deep occasion in our history. The United States of America is 248 years old since its independence, and for that entire 2.5 centuries, no Vice President of the United States has undergone. In a way, we are for the 13th Parliament, annals of history was undertaken to the process of impeachment in relation to the contributor in establishing the jurisprudence revolving around in our system of courts, High Courts, Court of Appeal, and the Supreme Court. We are not addressing a chamber that is dealing with a novel idea as decisions to apply the Constitution of the Republic of Kenya. That is by dint of Article 1, Article 10, of the Constitution in decision making is entirely in the province of the courts. This is an exclusive for the for governor of the exclusive jurisdiction that even the courts have spoken about many times. The courts, the trial court, if I may put it that way, is a repository of the law in regard to impeachment. All the cases courts have before a repository of the law officers by way of impeachment. It is the Senate. And it should not be lost historically from in our constitutional design was left to the Senate. It was a decision by the framers of our Constitution that this should be an exclusive matter to be dealt by the Senate. Having said that, I was advised by the National Assembly, who are clients, to read it. To carry this particular Bible, read the Bible about. This is in the book of Exodus, verse 22 and 23. And I read both the St. James Version, which is the one I prefer, which is in English. Ye shall not afflict any widow, shall wax hot, shall be, from the language is a little more palatable. Oh, you must not. And they cry to me and my anger shall flame out against you, and I will kill you with enemy arms. This is the Lord of the... Back to this matter later. But for now, I want to walk a constitutional journey with the Senate in giving upon the office of the President. We have no issue. And I want to persuade the rights as contemplated in the Bill of Rights, but it also addresses fears. Fears, and in the Kenyan people having given themselves this constitution, they were addressing rights and fears, and more importantly, they wanted to establish a system, the Senate, to of the seriousness of what before any functions of the oath or affirmation of office by the secretary to that schedule, and I want to of office opposed to the other oaths, including members of parliament. And there's a big distinction. And when it comes to the oath of the due, and that words there, that in consideration to the matters which are raised in the motion of impeachment by the National Assembly and the charges as they've been read out here. Now, the motion, the as follows. I diligently served, I pause there to emphasize those words that are found in the Constitution, that I will always, Republic of Kenya, and it continues to discharge my duties, that I will at all times, when so required, faithfully and truly give my counsel and so all with 3 words in affirmations for due execution of office which are found in the 3rd schedule are not contained in similar words when it comes to the spirit applies at the Constitution in terms of the election. Yeah, and the Deputy President, you'll find that, Mr. Speaker, sir, that the President and the Deputy President are elected at constituencies. At constituencies. And in that election, they must receive a majority of votes in at least half the constitution. And I say this with utmost respect that the Deputy President who stands here on trial by the Senate would assume, whereas the Constitution is clear, is elect president had to be elected from a constituency, a vice president had to be elected from a constituency as a member of parliament. This Constitution has no similar provision. The president should be between the president and the deputy, and those are found in Article of the President in the execution of the President functions, and also he may be assigned duties by the President. The kind of symbiotic relationship that should exist between the President and the Deputy President is the issue that I want to deal with in some detail. It is uncontestable from the record that you have, even from the Deputy President, that Kenya is like a company, Republic of Kenya. Shareholding is a republic of interest of watu Murema, or whatever that would mean. It is not in compliance. The second issue is on the question of collective responsibility. You would find out established under the Constitution of organs, like the National Security Council. So one would wonder where even the issue of the Director of Intelligence, when he established under, look at the utterances of the Deputy President vis-a-vis his role under the Constitution. He has said certain things in the Constitution because of what we have. Sub-Article 2 has a limitation that the commitment to violence, hate speech to put before the team. Where his brother, the next day, to execute a will, 2017. To doctors or physicians who are looking, and 7 days.
Or the Deputy President, very elementary decency. We owe it to the Deputy President, what is not contained in any evidentiary material before the Senate. I want to know which ground in the 11 grounds in the impeachment motion is this evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most basic decency. I object.
Refer to the document.
Volume 4. I have only 30 minutes. If you look at volume 4 of this document on public participation,
Yes.
pages, it's also contained the will. The brother of the Deputy President at that time was his daughter, was the only person present. And then there's the will on page 128. And this is why I was raising this matter. On page 128, there's a letter together with Mr. Gachagua were the joint will executors. And therefore, as an executor of the will, they read to Gachagua on page 129, paragraph 8. and got some funds from this account when the rich man was already withdrawing money. On the day he died, and that day when he died, he was again another limited. This story, and part of it is what Mr. Njomo was saying.
Counsel for Deputy President, please have your seat.
The document you are being purposes of our consideration, that's number one. Land travel to London, the back. Mr. Speaker, number three, I beseech this House direction. The facts are now being in the motion, unless Land Senior Counsel, His Excellency Governor Rengo, can draw your attention to any ground in the motion that those facts, the integrity of our check in this.
If you're going outside the necessary decision at the end of it. Now, Senior Counsel Rengo, there's an amendment that we've made that the Deputy President of the Republic of Kenya, on a certain date that we indicated, travel to London.
Yes.
Of the sickbed, he made his brother sign a will. Is that contained anywhere?
Volume 4 from the pages that at what time British Airways flight on the 16th, his documents is that until 24th, when the only activity in which he did participate was to be present. We have against
no objection made, but now we are conclude. In your opening statement, you may
say to the time when all I've guided proxy of the outspan and treetops for an amount exceeding 800 million shillings, and we're saying part of is not an offense by law. These were proceeds of crime committed by the Deputy President to acquire mine that the 200 million institution in excess of 200 million shillings were proceeds of crime. And that 200 million shillings, again, the documentation shops those of these properties what came out of criminal conduct, and all the particulars of the criminal conduct at the authority of the office of the Deputy President vis-a-vis that of the President, the doctrine of collective responsibility. And I showed certain functions been shown, acts of insubordination after the President, who is his boss. And if really one can talk about insubordination, is that every 5 years in the Senate, and they are about the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of not again born by the Constitution. Executive requires that public service out and in conflict with the provisions. Mr. Speaker, I would want this Constitution is supposed to work. It's supposed to work. And they can only work if they're compliant to the provisions of the Constitution. The doctrine of collective responsibility, and all individually, and that primary principle elected. So I urge this Honorable Senate, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, this Senate should not shy of that. There is a matter that could be taken to DCI or to the AACC. The role of Senate is different to manage the affairs of the country. And that does not depend on the role of any other agency or body, state officers. Whether it is that or it is not that person.
I'm afraid, Mr. President. Floor is yours.
I stand here to make the deputy distinguished senator with Senate, anything else framed the way it was framed. The deputy president reminds you the following terms in your oath of office: actually respect, uphold, preserve, protect, and deviously discharge. I submit to the deputy president, but that is only in the most technical sense. What is on trial? Our constitutional institutions of checks and balances, and actually their capacity to withstand Excellency regarding Gachagua. Our constitution conducts these proceedings, that at the end of this exercise, our constitutional order emerge stronger. Allow me to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme County be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the conduct of a state officer within allegations. Two questions. The assignment: is there credible evidence of extraordinary wrongdoing on the part of His Excellency Honorable Rigathi Gachagua? Proof of the allegations leveled against His Excellency Rigathi Gachagua. Article 150, the President from violation, serious national law, misconduct, cannot pass of the Deputy President. Or at the time, it is sufficiently notorious of the Republic of Kenya. With a view to finding which ground around what may or may not have happened, no your emotions. There is no route that you engage into in the discharge of your constitutional mandate and responsibilities. What does in process of any paragraph B has written down some? Secondly, an extra the president ought to start the president ought to start having the submission fallen short of the threshold. When you examine the material, fallen short of the threshold. When you examine the material before you within the following categories, then from falsehood, it will go to the ridiculous ones, and I'll demonstrate that shortly. There'll be ridiculous claims here. It will go to the ridiculous ones, and I'll demonstrate that shortly. There'll be ridiculous claims here. Then finally, a preview of some of these claims, so that we have an overview of the case that is before you. An overview of the case that is before you. At paragraph 7, members, allies, call corporate society in Madeira of any family member is supplied. No name of any ally. No name of any ally. No name, and in the documents before you, no name of any proxy is supplied in the motion or in any of the documents distinguished senators being called to defense a circle that we don't know. So now come and defend yourself. I began by saying some of these claims are either ridiculous. Or embarrassing. Secondly, has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed correspondence from any official complaint to this claim, which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, those of us who have some residual faith in our institution, he told the National Assembly, just a joke evidence. 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states